The judge is about to dismiss the case, and it takes all of my strength not to scream from the back of the courtroom. Hi, I'm attorney Andrew Flushy, and this channel is about defending your rights. Usually we talk about hypotheticals, but today I have a real-life court story, so stay tuned and subscribe for a new video every other Tuesday. A few weeks ago, I'm in a local courtroom watching a case about a Mr. Patrick Jones. Mr. Jones is in court over a reckless driving ticket. The deputy takes the stand, swears to tell the truth, and he begins testifying. Judge, I was called about some reckless driving. I went to the scene where I observed some muddy tire tracks running through the grassy median. A witness told me that a blue Ford pickup truck had driven through that median a few minutes before, slinging mud all over everything, making a mess of my road. The witness gave me the license plate of the blue Ford pickup truck. I ran the license plate through dispatch and it came back with an address. I went to that home and I located Mr. Jones to be the registered owner of the blue Ford pickup. I issued him a summons for reckless driving. He is the same individual who you see seated right over there at the defense table. At this point, I'm thinking Mr. Jones is going to win. There's literally zero proof that he did anything wrong other than owning a blue Ford pickup, and perhaps owning a Ford should be a crime, but it's not in Virginia. I sit forward on the edge of my seat, hoping, praying that Patrick doesn't testify in his own defense. I'm not representing Patrick in this case, but if I was, this is exactly when I would make a motion to strike. A motion to strike is when the defense lawyer argues at the close of the government's case that even if the judge or the jury believes every single piece of the government's evidence, there's still not enough evidence to show that the alleged offense was committed by this defendant. There is simply zero proof that Patrick himself drove any vehicle. All we know in this case is that Patrick owns a blue Ford pickup truck that allegedly was seen driving in the median, but there's no evidence that Patrick was the person driving it. If the judge agrees and grants the motion to strike, the case is thrown out right then and there. Patrick should have made this motion and he would have beat the case at that very moment. Sadly, our friend Patrick doesn't have a lawyer. He's representing himself and he opens his mouth to testify. I was driving in that area and the road was wet. I applied the brakes and my truck rear end began to slide. I lost traction and slid over into the median. I didn't hit anything, so I didn't think that I needed to stop at all. There was no damage, I just went into the mud. I bite my tongue hard because Patrick is defending himself against something he's not even accused of, hit and run. He's defending himself against some other violation that the officer's not claiming he actually did. Patrick is charged with reckless driving, not leaving the scene of an accident. And at the same time, Patrick admits to the judge that he did indeed drive his blue Ford pickup truck through the grassy median, and he admitted that he lost control of the pickup. Losing control and driving through the median is reckless driving, and perhaps owning a Ford should be reckless driving too. Patrick ignored rule number 1 for court. He who represents himself has a fool for a client. And by doing so, he wasn't thinking clearly about his case where he could analyze it in a detached way. He chose to testify, and he violated rule number 2. Don't incriminate yourself. If Patrick had kept his mouth shut and properly moved for a dismissal of his case, the judge would have been forced to dismiss the charge and Patrick would have been found not guilty of anything. Nothing would go on his driving record, no money owed, Patrick goes home and has a great lunch. This is one important reason why you should always have an attorney if you're summoned to court, to help advise you whether or not you should testify. In some few cases, your testimony is important or even critical for your defense, but in many cases, your testimony only will hurt you. If Patrick had hired me, I would have saved him a lot of headache and we would have been able to protect his driving record and insurance rates. Remember, don't talk to the police and don't be a fool in court by representing yourself. I don't care how much Law & Order you've watched. Be sure to lawyer up. For more court stories, check out how we won when my client was illegally stopped. I'll see you over there.